Maury, I think you're going to cover a couple of them just to give an idea of what we're talking about here.
Sure. And I'm not going to cover every trustee action that's listed here. There's not a lot of them, but I still don't want to necessarily weigh you down with covering every one, but I'm going to cover a couple. The first one is the first one labeled control. In my document it's labeled 9.1. Yours might be just slightly different depending on what you've had us put in your document. The only thing I really want to point out there is when we're talking about multiple trustees being involved, a majority of the trustees are going to be required to take action. So if there's 3 trustees, then 2 of them would be required to act. And if there's just the 2 of you serving, for example, then both of you would be required to consent to any sort of action. 9.2 in my document, it's labeled accountings, and that one talks about when an accounting is due. I want you to note that there's no accountings required as you as husband and wife are the beneficiaries and the trustees. You're not required to account to each other, you're not required to account to your beneficiaries, and what an accounting basically is listing out all the income and expenses of the trust. So you're not required to do any of that during lifetime, but this will become important if one of you dies or becomes incapacitated and a third party stepping in to either serve as co-trustee with the survivor or as the sole trustee. At that point, accountings would be required. Later on we talk about compensation. You should know that your trustees are entitled to reasonable compensation for their actions under this document. You can't expect people to work for free, even though I will tell you that most children do work for free when they've been named as trustee. There's a provision later that talks about exoneration of the trustee. Basically gives your trustee a little bit of peace of mind, saying that if they act in good faith in making a decision on behalf of this trust, then they can't be sued by any of the other beneficiaries. So again, so long as they were acting in good faith. And there's another section below that talking about bond. Basically what I want to point out there is your trustee is not going to be required to post a bond or go out and buy a bond from an insurance company to serve as trustee. And they're also not going to be required to go to the court to have the court authorize them to serve as trustee. So you're pointing out there in that section that they can serve without bond or without having to go to court.
Now, the next section that I want you to be concentrating on is entitled Trustee Powers. And this is powers that you're giving to the trustee to enable the trustee to carry out the instructions that you've given. There's powers given by state statute, which are more or less automatic for trustee, unless you would negate those. Your trustees do have those. And the trustee is then going to have what you've listed here in the trust, in addition to those state-granted powers. For example, 10.1 in my document, as Maury said all along, you're maybe a little bit different, but because of what we included in your trust. But 10.1 allows the trustee to retain assets, to keep exactly what you have at time of death. The trustee can keep that for ultimate distribution to your beneficiaries. The trustee can sell items. Oftentimes you'll see estate sales advertised, and sometimes there's a direction to sell. So you're giving the trustee the power to do that. Just as you at times find it necessary to borrow money, the trustee may need to borrow money. So there's a borrowing power in there. There's an investing power in there. There's just what we're trying to do is give the trustee all the power necessary for the trustee to carry out the terms and provisions and directions that you've given. All the way down to compromising claims, if there's a lawsuit involved, dealing with liability insurance, there's residence, you have a residence, you're giving the trustee the power and authority to allow your surviving spouse or the competent spouse to reside in that residence. So there's a lot of practical things in here. And there's one that you may have included after discussing the matter with either Maury or myself, and it's called catastrophic illness. If you want the trustee to be involved with gifting of your assets in order to try to protect them from the claims of long-term care facilities, nursing homes, you grant the trustee to cooperate in that type of action or gifting. So a lot in that clause, but basically you need to look at this trustee as a robot that you're programming, and if you don't give the trustee the powers to carry out the duties, then haven't programmed your robot properly. So you're kind of trusting Maury and I to put in the powers that the trustee is going to need. Next is administrative provisions. So we've got the trustee set up now, we've named them, we've given them actions that they have to do or that we're authorizing them to do. We've given them the power to handle the assets, and now we're saying, okay, we've got this all set up. There's certain things that you have to do as far as administration is concerned while you're operating as trustee. More?
Yeah, and again, under the administrative provisions, I'm not gonna go through each one. I'll let you kind of read through those, and if you have questions about them, feel free to ask. But I would like to touch on just a couple of powers in your administrative provisions. One is titled Small Trust Termination, and that's a provision that basically says if at any time it gets to the level where a trust created for a child or a grandchild or some other beneficiary is below a certain monetary value, and in this case we're saying $100,000, then your trustee is authorized to terminate that trust and pay it out to the then income beneficiary or beneficiaries. The reason they do that is because at $100,000 or less, the statute basically considers that a small trust, and they're saying that the cost of administering that trust is going to be outweighed by the benefits the beneficiary is receiving. So when faced with higher cost and lower benefits to your beneficiary, the statute and this trust is indicating that you probably would rather see your beneficiary get that money. Now, if you don't like that provision and want to change it, just let us know and we can make adjustments there. But otherwise, $100,000 or below, and we're going to be authorizing the trustee to terminate the trust and pay out. There's another provision a little bit later in called spendthrift provision. And basically what it says is no interest in this trust is assignable by or be subject to the claims of any beneficiaries or any creditors of a beneficiary. What that's basically trying to do is protect your beneficiaries from their own creditors. Keep in mind in the beginning I told you that any property that you put in this trust is not going to be protecting you from your own creditors. Unfortunately, you just can't do that and retain the benefits of the trust. But if, for example, you said that your children cannot have their property until the age of 50, for example, and they're only 40 now, well, at that point, the creditor of that child would not be able to get the distribution out early. So if your child isn't authorized to take the distribution, neither is your child's creditor. Therefore, that provision is basically saying, hey, to the extent that property is remaining in this trust, and there is that restriction there, it's protected from their creditors. That's the only couple I wanted to touch base on there. And then we move into Article, well, in my document's Article 12, yours might be a little bit different, but it's called Payment of Death Taxes, Expenses, and Debts. In the first one, we talk about payments, and it says after the death of either of us, the trustee shall make the following payments, and then we talk about paying all the death taxes that you might have by reason of your death, and any expenses of your last illness, funeral, burial, cost of administering the estate, etc. So the trustee is authorized and directed to pay those. The next article talks about debts. It says after the death of either of us, the trustee may pay all that person's debts. So that's a little different standard than we just talked about with death, taxes, and expenses, where we said the trustee has to pay those. In this one, they're saying the trustee may pay your debts that you might have at your death. And we're really trying to give the trustee some flexibility there to pay those if the trustee wants to, but have an ability to deal with creditors and maybe get those amounts reduced or threaten to not pay those if the need arises. I'm not going to cover, again, all of these different provisions. They're talking about tax elections that your trustee can make on your behalf and things of that nature. But I think what I'll do is move into the next article, which talks about definitions.
Maybe before we move into that, we've kind of completed the trust, and we've set up the trust itself, talked about it, talked about the trustee, talked about our children, our potential grandchildren, etc. What if we don't have any? What if we don't have any children left or no grandchildren? What do we do then?
That's a good point. Probably back in your document, if you turn back a little ways, we kind of skipped over that. But it's going to be after the provision that we have for your grandchild. I remember I talked about that. Whatever age you've selected, it's in there. Well, between that one and the time you get to the trustee succession, where you're talking about who's going to follow you in trustee, we're going to have something labeled similar to disaster clause. And basically what that is designed to do is say if at your death you have no children, you have no grandchildren, everybody that you wanted to leave property to is not there anymore, then you would have told us, in that case, where do I want my property to go? And we'll have spelled that out, make sure we've got that spelled out the way you want it. Now, if you didn't think that that was ever gonna be a possibility, you might have told us, just don't even worry about putting that in there, in which case, we've elected not to put that in there. But if we've talked about it and you've told us, for example, in that case, I wanted to go to a church, or a charity, or your favorite lawyers, wherever you've elected for that to go, it should be spelled out in the document.
But what if I don't? What if I told you, Maury, I don't want anything in there, it's never gonna happen? And it does happen, where does it go then?
Well, at that point, you're probably gonna be in court, and it's gonna be probably intestate at that point, and the
So
judge.
Illinois is gonna tell.
Yeah, the judge and Illinois law is gonna tell you where that goes, and most likely it's gonna go to your heirs, and we're talking about parents, brothers, and sisters, and the statute lists a laundry list of people that might get it. And a lot of times, those are the people that our clients don't necessarily want to get the property, which is why they've spelled out who they wanted it to get. So if you're thinking, I don't ever wanna deal with that issue, just leave it blank, just know that if you do that, it could go to ultimately the people you don't want it to go to. And it may go to the people you're okay with it going to. So just make sure that you kind of tell us what you want there and talk us through that, and that we've got it spelled out correctly in your documents. The next article up is, it's called definitions, and I'm not gonna go through each definition here, but you can read through those if you have a question about what something means in the document. We've probably spelled it out in here. But I wanna point out a couple of provisions with respect to child and descendant. And the only thing I really wanna point out there is make sure that we've got a definition of child and descendant that you think is appropriate. And more particularly, if you've mentioned adoption to us, whether you want adopted children or grandchildren included or excluded, that in the definition of child and descendant, we've spelled that out the way you wanted it worded.
What about stepchild? Does that include stepchild?
Yeah, stepchildren are not gonna be included in your plan unless you specifically told us to include a particular stepchild or stepchildren. Otherwise, stepchildren are out. Adopted children are gonna be included unless you told us, an instruction otherwise. And again, regardless of which way you've done an adoption, make sure it's stated in here the way you feel. And the only way a stepchild would be converted into someone who's gonna inherit is if you spelled out that adoption is okay, and that stepchild is actually adopted. And again, if you've not told us anything, under the general rule, adoption is gonna be included in your plan. So any children or grandchildren that are adopted are gonna be a part of the bloodline. We go through some other definitions in here. Just go ahead and check, if for anyone you might wanna review a little bit more on, read through that, let us know if you have any questions. And then it ends with a blank for your date. When you come in and sign the document, you're gonna fill in the date for us there. Make sure I've got both of your names spelled correctly, and you guys are referred to individually and as trustee, because you're signing on your individual behalf, and you're also gonna be the first trustees of this trust, so you're signing as trustees. The next page should be the notary page, which would be the final page of your document. Make sure, again, I've got your name spelled correctly there. Now from here, if you have any questions, again, you've got your red pens, make your notes, and then either call Melissa and let her know what your changes are if they're minor. If you want to talk through the document in more depth, or any particular provisions in more depth, just go ahead and call and make an appointment to talk to one of us to do that. And of course, if you have significant changes, definitely contact us and let's sit down again and talk about it. Otherwise, that is the summary of your will and your trust. If you have questions, again, just go ahead and feel free to give us a call. Right.
Thank you very much.